It is noon, so we will go ahead and get started. We are recording this webinar, so we will send the recording of the webinar to everyone who has registered for the webinar. So if you have to hop off early, don't worry, we will send the recording to you so that you can catch all the information. My name is Emily Sumner. If we have not met before, I know some of you very well, and others I don't think I've met before. So I'm so glad that you're here. I'm so glad that you're here live so that you can ask questions. I want this to be an interactive experience. Feel free to put questions in the chat as we go through the slides that I've prepared, and then I will also leave time for questions at the end. I will keep an eye on the chat for questions. I may tell you, hold on just a minute, we're getting to that in a few minutes, so be prepared for that. But please do feel free to put questions there. This is for you, and I want you to come away from this with answers to the extent that we have answers to questions. So what we're going to talk about today, what is an H-1B visa, an overview of the H-1B CAP registration process, the weighted selection process. So DJ, if you all took a look at the questions in the chat here, DJ told us that, or asked a question about the weighted selection. We definitely will be talking about that. We'll be talking about status-specific considerations, the $100,000 fee, when that applies and when it does not apply. Spoiler alert, it does not apply as often as you might think it does. Approaching your employer if you are an individual employee, employer obligations if you're an employer, and then we'll talk very briefly about considerations for if you or your employee is not selected. But we typically do another webinar about that in April. So we're not going to spend a lot of time on that, and we have a lot to cover today. Before we proceed further, can you all just put in the chat that you can hear me? One time, this was years ago, but I started a webinar like this and nobody could hear me. So DJ says yes. Karen says yes. Awesome. Thank you so much. All right. So what is the H-1B visa? We're going to go through this quickly because I know based on some of the names here that you all know very well what an H-1B visa is, but we'll go through it quickly. So what is an H-1B? Who's eligible? What is the H-1B cap? And why did the government change the process? We have a lot to unpack there. So an H-1B visa is a non-immigrant visa classification. It is a temporary visa classification. When I say temporary, it is valid for up to 6 years total, and it can be extended beyond that. A U.S. employer has to file the petition on behalf of a prospective employee. It is possible to self-sponsor for an H-1B, but the petitioner, the employer, has to be a U.S. employer, so based here in the United States. It is for a specialty occupation. The H-1B is for specialty occupation positions. That is defined as an occupation that requires a minimum of a bachelor's degree in a specific field of study. There is a limit on the number of new H-1Bs every year, specifically 65,000 plus an additional 20,000 for U.S. master's degree holders. So there's something I was going to say about that. Oh, I know. The transfers, amendments, extensions do not apply to the cap. Also, there are certain organizations that are considered cap exempt, such as institutions of higher education. Certain nonprofits, not all nonprofits, certain research organizations are considered cap exempt, and they don't have to go through this lottery process. But in general, there are so many people who want a new H-1B every year that there is a lottery that is conducted in March, and that's what we're talking about today. So who is eligible for an H-1B visa? Like I said, it's for positions that require a minimum of a bachelor's degree in a specific field of study. So that's really something that we're looking at when we are evaluating a position for a potential H-1B. One source that we look at, it's not cut and dry. It's not, if the position isn't even in the source, it's not the end of the world, but we look at the Occupational Outlook Handbook to see what that says. That is published by Department of Labor, and it's available online if you Google it. But we look there because that's where USCIS looks to see if they think that a position requires a minimum of a bachelor's degree in a specific field of study. There's some occupations that aren't listed there at all. There are others that are listed and they don't have a great looking entry. So it's a starting point, but it's not the be all end all. In addition, we have to look at, does the position require a bachelor's? Does the employer require a bachelor's in a specific field of study in real life? And does the employee, the potential H-1B beneficiary, actually have at least a bachelor's degree in a specific field of study? So that would be you can look at either the underlying bachelor's degree, or you can the bachelor's degree that the person has, or we can consider a combination potentially of education and experience. So we've had numerous clients over the years that don't necessarily have, they may not have a bachelor's degree at all, or they may have a bachelor's degree that is not in the required field of study, but we can combine experience. So just know that that is a possibility. As I said, there is a limit on the number of new H-1Bs available every year, 65,000 plus 20,000 for US master's degree holders or higher. If a person has a US master's degree or higher, in order to be counted in that 20,000, the additional 20,000, yes, this limit is true for this year as well. The degree has to be from a university that is accredited and from a university that is not for profit. So there are some universities that are unaccredited. There are others that are for-profit organizations. Those would not count for the 20,000. The Neela asks if the limit is true for this year. Absolutely. This limit of 65,000 plus 20,000 is also true for this year. It's in the statute, which is hard to change. Literally takes an act of Congress. So the new H-1B cap process, what does this look like? When I say new, it's new as of 2020. And that seems like, in some ways, yesterday, and other ways seems like 100 years ago. But before 2020, the process was we would, for this H-1B lottery, the lottery still happened, right? But we would prepare an entire H-1B filing. So we would file the labor condition application, prepare all the forms, the support letters, supporting documentation, and send in an entire package to USCIS. Then they would enter that information into some basic information into their system. They would conduct a lottery, and we would get packages sent back to us that were not selected in the lottery. It was inefficient, to say the least. So in March of 2020, nothing else was happening then, right? Haha, that's when COVID hit. They rolled out this process. They rolled it out before they knew COVID would hit. But anyway, they rolled out this process. So we've been working with it for, this will be the 6th year now, where we enter some basic information into the USCIS system directly. It's called a registration system. So we do not prepare the entire H-1B petition package until we know the case is selected. It will be slightly different this year, and we'll talk about that in a minute. And then there's a lottery, and we want to talk about, of course, what information is required. So for an H-1B registration, so we're not talking about after the cases, after the registration is selected, there is additional information that's required then. But for the actual submission of the registration, we will need certain information. Sorry, I skipped way ahead here. I don't know how this happened. It's like I skipped to the end. Okay. So we'll talk about this information. So the pre-registration process, so the registration process, employers register the beneficiaries, or we, for the employers, will register the beneficiaries in the H-1B cap lottery. The registration period is open in March for a period of about 2.5 weeks. Typically, they announce the specific registration period in early February. So be looking out for that in the next week or two. And we'll announce that as well once we have that information. Registrations are employee specific. So as an employer, you cannot say, hey, I know that I have an opening for 5 individuals. I have 5 positions that I need an H-1B for. So let me just register 5 H-1B registrations. You have to identify the specific person. And then the registration fee is $215. That increased, I think it was last year that it increased for the first time. So the lottery process is that USCIS will select we enter all this data during the registration process into the USCIS database. USCIS will then conduct a lottery at the end of March. They will conduct the lottery by selecting 65,000 registrations, and then of everyone who's left who has not been selected, USCIS will then select an additional 20,000 for the US master's degree registrations. It's possible that there would be a later selection in July, summertime. That did happen in 2023 and 2024, did not happen in 2025. So we'll have to see if that happens this year or not. But for now, count on the lottery being done in the lottery being conducted by the end of March, and we should know by the end of March if a case is selected in the lottery. Weighted selection. DJ, this is what you're asking about, and I'm sure everyone else has questions about this as well. So what is the weighted selection of H-1B registrations? As you may know, the administration has published a final rule, a final regulation that says that instead of having a random lottery, now we're going to have a weighted selection. So the weighted selection process, we'll talk about on the next slide, but in more detail, but the weighted selection process is different for this year. Keep in mind that the weighted selection process, the regulation is in place. It's supposed to become effective February 27th, I think is the exact date. So it's supposed to become effective in time for this year's lottery. So right now, the way that we're preparing internally, that we will advise our clients to prepare, we are counting on the weighted selection process being in place. However, there is and will be continue to be litigation about it. It is against what the regulations say, and there's solid ground for, I think, for litigation for this. And so it's possible that the implementation of the weighted selection process will either be delayed until next year or a subsequent year, or that it will be struck down altogether as being outside of the rules that exist right now. You know, the agency can't create rules not based on statute. Anyway, know that this is frustrating, right? Because today is what, January 27th. The registration period will open in just a few weeks, like less than 6 weeks. And you would think we would have solid information, but that's not the world that we're existing in right now. That's not how things are right now. So, like I said, as of right now, we're advising clients, assuming that the weighted selection is going to be in place, but just know that that may change in the future. We'll, of course, keep everyone updated. So what is the weighted selection? As you may know, when an employer files an H-1B petition for an employee, for an H-1B beneficiary, the employer has to attest that they will pay either the prevailing wage or the actual wage, whichever is higher. The actual wage is what the employer pays to similarly employed employees, individuals. So somebody in the same or similar position with the same level of education and experience, that type of thing. The prevailing wage is set by the Department of Labor. Within the Department of Labor, they have a database, which is where I pulled this image that we're looking at right now. So on this database, when we search for a wage for our clients who are filing an H-1B, we input we select the right wage information, the wage database to begin with. But then we input the job title. There are a finite number of job titles. Not every job title that exists in reality in the world is going to be in that database. So we have to select what's called the closest SOC code, standard occupational code. What we're looking at right now, the SOC code you see here is 151252, and the title is software developers. So this is the wage information that would apply for software developers, which also can include software engineers and similar titles. Yes, you can check this database. Don't let me forget to, it's the, I think if you Google OFLC wage database, it should come up. The trick is you have to make sure you select the right database, the most recent year, and then all industries, not the higher education, unless you're a university. So back to the prevailing wage. This is the prevailing wage. You will see, I just selected this as a random example because you have to select an SOC code and you have to select a geographic location. I randomly selected Mecklenburg County, North Carolina, which is near Charlotte, North Carolina, and software developers. And you will see, thank you, Barbara. Yeah, the location plays a role, absolutely, which is what I'm saying right now. The geographic location that I selected for this is Mecklenburg County, which is near Charlotte, North Carolina, and these are the wages that the database came up with. You will see that there's a set of 4 wages, right? Wage level 1, wage level 2, wage level 3, wage level 4. There is a framework, what do you call it? It's like a table that they use. Anyway, there's a grid, I think is the word I'm looking for. A rubric is the word I'm looking for. There's a rubric that Department of Labor uses supposedly to guide us and them in setting wage levels, or determining, not setting, but determining wage levels. So for example, The wage level 1 is designed to be for entry-level positions. So again, we're looking at software developers near Charlotte, North Carolina. For entry-level software developers, Department of Labor is saying that the prevailing wage for entry-level positions is this 91,000 amount, 91,291. Wage level 4 is for senior most individuals in this particular occupation. So we're not talking about now you started out as a software developer and now you are the chief information officer. That's a totally different occupation. We are looking only at the occupation of software developer. So if you have the senior most, somebody who's very senior as a software developer, they would likely get wage level 4, be assigned wage level 4, which is this 154,669 number. Positions that are, between entry level and senior most positions, wage level 2 and 3. So perhaps wage level 2 is someone with several years of experience. Maybe wage level 3 is somebody who the position, and remember, it's not necessarily what the person has, it's what the position requires, which is a nuanced distinction, but important. But if the position is one that requires, let's say, a master's degree and a few years of experience, it may be wage level 2. Again, there's a rubric Department of Labor uses, and we can help with that as part of the services that we provide. But bottom line is the position that's being offered will be assigned one of these wage levels, wage level 1, 2, 3, 4, depending on what the position requires, not necessarily what the person has. It should match up, because if you have a person who has 25 years of experience and you're saying that they're now working in a wage level 1 position, we're probably going to get questions on that from USCIS. But these are the 4 wage levels. I said a minute ago that a person has to be paid, an H-1B beneficiary has to be paid the higher of the prevailing wage or the actual wage, whichever is higher. So keep that in mind, that if you have an entry level, for example, software developer, and every other entry level software developer that you have, you pay $95,000 a year for this particular geographic location, and like I said, similar positions, similar education and experience, then you need to pay your H-1B employee that amount as well. That would be the amount that you have to pay, the 95 instead of this 91. Bottom line is we need to know that there are these 4 wage levels. Okay, that's important. So any questions about these wage levels before we move on? And to be clear, I said this a minute ago, but DJ and everyone else, yes, the geographic location absolutely matters. The Department of Labor does surveys, they say. I guess they do. They do surveys, wage surveys, based on geographic location. So they are saying that in the Charlotte area, this is, I don't know exactly how they do the calculations, but this is the average of what a person is being paid depending on the wage level. That amount, the wage level, is going to be different for somebody working in San Diego. That will be different for someone working in Seattle, New York City, Boston, any of that. Yeah, remote employees, that's fun. Remote employees, if my work location is different from my company. So the wage level is set, it's defined by the work site location. It's the legal term is the area of intended employment, which is where is the person actually going to be sitting when they work. So in my company, in Sumner Immigration Law, we all work from home 100% of the time. So I have employees who work in Texas, New Jersey, Massachusetts, Florida. Anyway, we're all over the place, Virginia, obviously. So if I were filing an H-1B petition for my paralegal who lives in Texas, her wage would be set based on the wages exactly where she lives in Texas, not based on the wages in Richmond, Virginia, where Sumner Immigration Law is based. And the same applies for, any number of other, if a company is filing an H-1B petition. Depends on where the person's working, whether they're working from home or working at a client site, whatever the situation is, it's based on where they're working. So the registration system that was implemented in 2020, we'll take a look in just a minute. That's a good question, Neela. We'll take a look at in just a minute about right now, about the changes that we've seen and the numbers of registrations, starting with the new registration system. So we're not talking about the wage level, the weighted selection anymore necessarily right now. But this table shows us the data over the years since the change in the registration system. So remember just a minute ago, I said that before 2020, we would prepare entire petitions and submit them. These were the numbers pre-2020. So 2016 was 236, 199, 190, 200. The first year of the system, the new system where you just register on the USCIS site went up some to 274, then 308, and then look, by 2023 it was up to 780,000 registrations, which is crazy. USCIS selected 188 of those registrations. Then it's gone down. It went down by half in 2024 and then down again in 2025. So it will be very interesting to see what happens in 2026, this spring, in terms of the number of registrations that USCIS receives. My guess is it's going to go down for a couple of reasons. One is because we do have, assuming the weighted selection process sticks, then we are going to have to do some initial more analysis, more legwork before we actually submit the registration. And I think some employers will be scared off, potential employers will be scared off by the $100,000 fee, either because they were actually recruiting individuals from overseas, so they would have to pay the $100,000 fee, or because they just don't understand. I think it has a chilling effect, which is unfortunate and can be to the benefit of individuals who are proceeding and registering. If there are fewer registrations, higher chance of being selected, although admittedly, the weighted selection will definitely affect that. Before we had this weighted selection process, one of the things that we cautioned employers about was the danger of registration without analysis. You would not want to submit, I think it's irresponsible to submit a registration without doing some initial analysis to make sure that the position is actually one that requires a bachelor's degree, and the person actually has the required degree. Because you could just, an employer could just submit, 100 registrations, see what sticks, what happens, and then end up with selections where the person actually is not qualified. So let me answer Neela's question, because this is a good one. Are the wage levels going to change before the lottery? So there have been rumors about a proposed rule that would change the basically increase the wage levels. So when I say wage levels, I mean the Department of Labor database wage levels that we looked at a few minutes ago. So I think the answer is no. Who knows for sure? Crazy things are happening right now for sure. And we are here to guide you through step by step, but I don't think it'll change. At this point, I don't think the wage levels will change before the registration or before the H-1B, before we file H-1B petitions. Could be wrong, but I don't think they will. So the timelines for registration. We are beginning now and have been through January to prepare H-1B registration. So if you are an employer or an employee and you know that you want to register or be registered for the H-1B lottery, then we're starting to prepare everything now. We will do the case analysis and registration now and into February. We will register the cases in March. Like I said, the exact window has not been announced yet, but we'll let everyone know when that is. USCIS will conduct the lottery by the end of March, and they will notify us of the selection by the end of March. Keep in mind that if you or your employee is registered in the H-1B lottery, we'll get a notice saying you're selected. We will not get a notice saying you're not selected until much later in the year. So really what you're looking for towards the end of March is a notice that you were selected or your employee was selected. We will file for the cases that are the registrations that are selected. We'll file those cases between April and June, April 1st and June 30th, and then hopefully we'll have a decision between April and November. I am hesitating because it is January 27th and we still have H-1B petitions that we filed last April to June that are still in process. So who knows? So what we can do for you. And before I'm going to go through this slide, and then I want to hear it. I want you all to put in the chat what you want to hear more about. We have the $100,000 fee coming up, and we can talk more about the weighted selection. But I want to know what you want to know about, because I know we have several people here, not everybody, but several people here who have a lot of experience with this. So I want to know what you want to know and what you want to hear about. So what we can do for you, we absolutely will be doing pre-registration case analysis. So that means that before we register a case, yes, we will walk you through the weighted selection process. So that means that we will gather information from you as the employer and from the employee about the proposed job title, the job duties, the salary that you're thinking of offering. We need to confirm the geographic location, the area of intended employment, where the person will actually be working. And we need to look at the degree that the person actually has so that we can strategically work with the employer and come up with an appropriate SOC code, standard occupational code, and wage level. I didn't mention this a minute ago, and I think you all know this, but with the weighted selection, I forgot to mention this important detail. With the weighted selection process, we talked about the wage levels, right? Wage level 1, 2, 3, 4. And we said that when we register, before we register, the employer will have to commit to a specific wage level. So that's part of this analysis that we're doing, right? We're talking with the employer about what is the job title, the job duties, and making sure we have an appropriate SOC code and an appropriate wage level. With the weighted selection, and USCIS has not given us much information at all. All we have is the final rule, the final regulation that came out on December 23rd. Fun, right before Christmas Eve. But we have that final rule, but we don't have any other information from USCIS right now as to what the registration system will look like. They're going to have to change their interface to gather this additional information. We don't have details on how the lottery, specifically how the lottery will be conducted. What we know, and by that I mean with the weighted selection, what we know from the regulation is they say that if a registration is wage level 4, that registration will be entered into the lottery 4 times. If a wage level or registration is wage level 3, they will be entered 3 times. If it's wage level 2, they will be entered 2 times. Wage level 1, it will be entered 1 time. So the idea, I believe, I think the administration's idea behind this is to reward positions that are being paid more. That is the extent of what we know from USCIS officially. Like I said, we don't have additional information now on exactly what information they're going to ask for or what the interface is going to look like or specifically how the lottery will be conducted. Yeah, that's a great idea. Let's talk about that, Akila. There's a question right here I want to talk about in a minute. So we don't have a lot of information right now. So that is unsettling. We as lawyers like to plan ahead. I know that you as employers of foreign nationals and foreign nationals yourselves would love to plan ahead and know what's happening and have some sort of plan. We absolutely can have a plan in place for sure. So like I said, we know just based on our experience and the limited information we have, we know the basic information that we need to collect, and we will start and have started doing that analysis now. So let me finish this slide and then let's come back to that question, Akila. So the pre-registration will look at the background, all that information that I just said, and make sure that we have that information on hand because it will be important to strategically and accurately select the wage level, right? Because if you have a wage level 4, and this I think goes to what you're talking about, Akila. If you have a registration that's wage level 4, then ostensibly that will get you 4 entries into the lottery, right? Which sounds great. However, if that SOC code is inappropriate, then you have a higher chance of the case being denied when you actually file the H-1B petition. Here's what I mean by that. A couple of things. If the SOC code is one that USCIS traditionally does not think requires a minimum of a bachelor's degree, then it's much more likely that the petition is going to be denied, even though it's a wage level 4. That's different from does the occupation require a minimum of a bachelor's degree to enter the profession. So for example, if we were to file, I wouldn't do this, but if we were to file an H-1B petition as a computer programmer, as wage level 4, instead of entering submitting the registration as an SOC code of, for example, software engineer, as maybe a wage level 2 or 3, that could be problematic because USCIS could say, oh, but a computer programmer doesn't require at all, like no matter how advanced you are, doesn't require a minimum of a bachelor's degree. And there's definitely room to argue, but it's risky, right? And we have to be very strategic and intentional about the SOC codes that we're selecting, the wage levels that are appropriate, and what the individual H-1B beneficiary actually has in terms of their qualifications. So it can be risky to do wage level 4, because you might have the wrong an SOC code that USCIS believes is not H-1B worthy, where it doesn't require a minimum of a bachelor's degree. It could be that an employer would like to use an SOC code because they can then select a higher wage level. But that SOC code, even though that particular SOC code maybe corresponds to an occupation that does typically require a bachelor's degree, we also have to make sure that that SOC code aligns, that occupational classification aligns with what the job actually is, right? So there's sometimes when an employer will give us a job title and set of job duties, and we have to work with the employer to do research to see there's not an exact fit for the SOC code. We have to do research to say, oh, it looks like SOC codes A, B, or C could possibly be appropriate. What do you, employer, think? Who's working in the industry, you really know, you're the expert. And we have to select the right SOC code. It is possible that USCIS would challenge the SOC code selection and say, oh, actually, employer, you should have selected this other SOC code instead, because that's more closely aligned. So that's also a risk. Sometimes what we have done, and I don't think it's going to be possible now with this weighted selection process, sometimes what we've done where we're not sure, where we think USCIS could challenge us on the SOC code selection, we have filed, we register the case and the H-1B lottery. We only have to include basic information so far, until this weighted selection there. Then when we file the H-1B petition, we have 2 LCA certified, one for one SOC code that we think, that we're going to go with, we think is appropriate, and then a backup one that we think, oh, USCIS might think this is more appropriate. That LCA has to be certified before we file the petition. But in this situation, when we have weighted selection, it seems like, and nobody knows for sure because nobody's done this before, and we have very little information, but it seems like we will have to be like firmly committed to the SOC code and wage level that we select for registration. I don't think it'll be possible to then change it down the road and to think, oh, this is actually a better selection. So we have some good questions here. Let's come back to those. So we have the pre-registration, back to what we can do. We have the pre-registration case analysis. Then we will register the case for you. And then once, monitor the lottery, we keep everyone updated. There are lots of emails that go out in March to, confirm that the registration is properly submitted. And then we keep everyone updated on USCIS conducting the lottery. Like as soon as we start getting emails from USCIS, of course, we notify our clients, the employers, but we also will send a blanket email that says, hey, we've started receiving some selections, but it's not done yet. So don't freak out yet. Wait till you hear from us. And then we help, of course, we walk employers step by step through preparing and submitting selected petitions. So let's take a look at these questions that we have here. Akila asked, does the weighted selection account for candidates who exceed the minimum role requirements and are compensated at a higher level of experience compared to the job offer? That's a good question, and it's a complicated question, right? So I think it's hard to answer that with specificity, just in a hypothetically speaking, right? But I do think it's really important that you look at the actual job that's being offered. What are the requirements of the actual position that's being offered? And in some situations, there's not, how hiring is in real life. A lot of times there's not a written job description, which is frustrating for us as immigration lawyers, but it is what it is. It's real life. Sometimes there's not a written job description or not formal requirements set in place. Other times there are. So if there are, that's what we would look at. We would look at the job posting, whether it is from the client or our client, the employer, the actual employer, or if you're being placed at an end client site, the H-1B workers being placed at an end client site, we see what their minimum requirements are. So that's what we look at, is what is the employer's actual requirements for the position and what does the employee, the H-1B beneficiary, have. So if you have a situation where the H-1B beneficiary is more advanced, let's say, in this market, it may be that a person takes a position that is lower wage level. But if, let's say, a person has 25 years of experience and the position requires a bachelor's degree and 0 experience, in theory, that could be, you could register that case as a wage level 1, and you should, because that's what the position actually requires. but then the employee would actually need to be paid a wage level one. I think if you submit it as a wage level one and then you pay the employee as if, you would for a person who has 25 years of experience, that's going to raise some red flags down the road. Maybe not immediately, but down the road, I think it would. So you have to look at both. What does a position actually have? What is the beneficiary actually? What are their actual qualifications? And then look at the salary. And ideally, all of that would align. It's not always going to, but we have to be careful of misalignment because that can create red or yellow flags for USCIS. So that's a non-answer for you, but it gives you an idea of the types of things that we need to be thinking about. Vishnu asks, are there any supporting documents to be uploaded or roles to be provided during the registration to support the SOC code? That's a good question. And as far as I know right now, no. But I say that because we don't know what the registration system is going to look like. Like I said, they have not given us any idea what the interface is going to look like. I imagine not. I imagine that we're just going to submit the documentation and then, or, to submit the registration, do our analysis and strategy session, and then submit the registration. And then it'll be, if that comes up at all, it'll come up when we file the H-1B petition. You all have great questions. Keep them coming because I think these are really helpful for other people as well. So if you are a foreign national employee and you are interested in approaching your employer, these are some about being sponsored for the H-1B. These are some things that you can think about. Your employment. Are you currently eligible to work in the United States? The employer may ask you this if you're looking for a position. It's very common for an employer to ask you, are you currently eligible to work? Do you now or in the future require sponsorship? If you do require sponsorship, like H-1B or another visa classification, you should say yes to this. It's frustrating. I know you don't want to go into an employment situation. You're just so glad to have a job. You don't want to go into an employment situation and say, by the way, I need you to go through this extra hoop. But that is, in the interest of transparency, it's helpful for the employer to know that. An employer is not supposed to hire or to not hire, to decline to hire based on the duration of the employment authorization document. So if you show a OPT EAD or STEM EAD and it's valid for a few months or several months or a year or whatever it is, they're not supposed to decline to hire just based on that. An employer does not have an obligation to sponsor for immigration. They can choose to, and I hope they do, but they're not required to. An employer may want to wait. For example, if you have OPT and you know you're eligible for STEM OPT, or maybe you're on your first year of STEM OPT now, an employer may say, oh, let's wait and see how things go. And that's from an employer standpoint. As an employer myself, I get it. It makes sense. Also, from a foreign national standpoint, advocate for yourself. Explain to them why this would be really beneficial for both of you to go ahead and register now, because you may or may not be selected this year. So for the registration process, the information that will be required, and like I said, this is subject to change, but generally speaking, it's basic information from the employer's name, legal name, tax ID number, office, contact person. From the beneficiary, general information about the beneficiary, such as your name, gender, whether you have a master's degree or not, date of birth, passport number is tremendously important, because the selections are done based on your passport number. They're not done based on the employer themselves. It's based on the individual employee's passport number. And then this is new for this year, right? So we have looked at this previously in previous years to make sure that the position is H-1B eligible, but it will be tremendously important this year, assuming the weighted selection process stays in place. We will need things like the job title, information like the job title, the job duties, the minimum requirements for the position, the proffered wage, what you're thinking of offering the person for H-1B, and that can be different from what they're being paid right now. So if you have an employee who's working on OPT or STEM OPT, or even something like L2 or E2, they have a work permit and you're sponsoring them for the H-1B, you do not have to pay them the H-1B wage until they receive the H-1B, until they start working in H-1B status. And then we'll need worksite location as well, because like I said, the required wage is dependent in part on the area of intended employment. So the H-1B filing in general is employer driven. It's absolutely okay for the employee to be involved and advocating for themselves. But there are things the employer cannot be just totally hands off and be like, "We'll go find a lawyer and go do it." There has to be involvement from the employer as well. So there's documentation, general corporate documentation required from the employer. There are going to be forms that we prepare for the employer to review and sign. The employer, by regulation, has to pay the H-1B legal and filing fees, and the employer has to make certain attestations on the labor condition application, namely about the wage they're going to pay, that there's no adverse impact to existing employees, there are no labor issues, and they have to offer to return transportation to the most recent country of residence if the employment ends before the H-1B position or H-1B petition ends, status ends. So these are considerations for the H-1B employer. And I'm mentioning this because it's a question that thoughtful H-1B employers or prospective employers ask. So yes, there are things that they will have to do. That being said, we as the immigration attorney make it as streamlined and as easy. We do everything that we can for you as the employer to make it as easy as possible. I know that most of the time, a company does not have a dedicated immigration person, and this is not your full-time job. So we make it as easy as we can. Just a minute, we'll come back to this question in just a minute, Hussein, but don't let me forget. For the H-1B filing from the employee, like I said, we need degrees, transcripts, credential evaluation if you have an overseas degree, copy of your resume, documentation of immigration status. That is going to be tremendously important. We want to see, where you are right now, but then also in terms of analysis for the $100,000 fee that we'll talk about in just a minute. That will come into play, documentation of your current status and previous status. So let's look at Hussein's question. Regarding the SOC codes for last year's H-1B cap, we primarily filed under codes 15, these codes at wage level 2, and we received 100% employees approvals. We're planning to file under the same SOC codes at wage level 2 again this year as well. Okay, that's fine. I'm not sure what your question is, Hussein, if you have a question. If you have a question, let me know. But I think that's fine. If the positions are ones that require where it's appropriate to file as wage level 2, given the requirements for the position, I think that's totally fine. The only thing to be aware of, and like I said, you have to be accurate. You can't just go filing wage level 4 just because you want a higher chance of being selected in the lottery. But just know if you file in wage level 2, then the H-1B beneficiary will have 2 selections in the lottery or 2 entries in the lottery instead of 4 for positions that are wage level 4. But again, make sure it's accurate. Don't go filing in wage level 4, doing registrations in wage level 4 because you want a greater chance of being selected in the lottery. It has to be accurate. And that shouldn't, there are a number of factors, but wage level 2, once you file the petition, that should be fine in terms of approval. All right, so we talked about the H-1B filing. We're gonna skip this, not selected. And we'll talk about upcoming changes. We'll come back to the not selected if you all want to talk about it and if we have time. So upcoming changes in the H-1B process, especially the registration process, weighted selection, like I said, USCIS has said, and other DHS have said that there are going to be more site visits for compliance, and that could absolutely be the case. So far, what we have seen and heard of more is ICE visits, especially like ICE raids in perhaps facilities where there are a number of undocumented individuals. So I'm not saying site visits don't happen. They absolutely do. We have seen more FDNS visits and inquiries before. That's the fraud detection and national security, where they ask questions to confirm that a person is actually doing what they said that they were going to be doing in the H-1B petition. So I think that's possible. Like I said, or I didn't say this before, but I think it's possible we'll see stricter adjudication, potentially more requests for evidence and notices of intent to deny. We're seeing that in general across the board for immigration filings. It's not awful, knock on wood, right now. But we're seeing that they're finding things and looking into things that they did not before. So I think the key there is not to be afraid, not to say, oh, I'm not going to file because I don't want to be involved in this, but to take a deep breath and to make sure that information that you're submitting is accurate and truthful and consistent with information that you've submitted to immigration previously. And then Neela asked this a minute ago, Are there going to be changes to the required wages? That has been floating around for years, and I don't think so. I haven't heard of anything imminent. We will, of course, let you know if and when that does come up again, but for right now, no. So, next steps to proceed. I want to talk about the $100,000 fee, which I may have skipped accidentally. Yeah, here we go. I don't know why I skipped slides accidentally, but here we go. We're covering what we need to cover. So the $100,000 fee. Let's talk about Nishant's question first, and then we'll come back to the $100,000 fee, and then it'll probably be about 12:50 then, and I'll open the floor to questions. Additional questions, which you guys have had a lot of good ones. For the worksite location, Nishant says for the worksite location needed to be provided by the employer for H-1B lottery registration. As a remote employee, can my company put a future potential location? Interesting question. For when the H-1B lottery gets selected and filing actually happens. That's an interesting question, a great question, and we don't know for sure because, like I said, we don't know what the interface is going to look like, and we don't know, nobody has done this before, so we don't have past experience. I was in a consultation earlier today, and I told the prospective clients that so much of what the advice that we give as immigration attorneys, yes, is based on statute and regulation and policy memos and things like that. But so much of it is based on actual practical on to the ground experience. And we don't have that yet for this. So we don't know. I would say for the registration to make sure it's as accurate as possible. What you don't want to do is say, oh, let me look at the wage levels for rural Kansas, because surely those are lower, and I might move there by the time and I'm not saying this is what you're going to do, Nishant or anyone else, but you don't want to say, oh, the wage levels there are really low, and I might move there by the time we submit the H-1B petition, so let me use that as the work site, and maybe it'll change in the future, maybe not. I know it's hard to predict, especially with the work from home situation, which a lot of us have right now, but I think we need to be intentional about that and as accurate as possible. So I don't have a specific answer, but I do think we need to be careful about that. Neela, what about STEM OPT EAD holders? If you could clarify that question while we're talking about the $100,000 fee. So the $100,000 fee, let's talk about that, the $100,000 question, right? So who does the $100,000 fee apply to and who does it not apply to? And I want to be very clear about this. And you all put questions, which you already have, you're doing right now, awesome, in the chat about the $100,000 fee, because I have heard so many people just out in the wild, if you will, out and about, say, oh, the $100,000 fee applies to every H-1B, and that is not true. I was at a conference week before last, and somebody was talking about the $200,000 H-1B fee, and I said, no, there is no $200,000 H-1B fee. It's a $100,000 fee that only applies in limited circumstances. So the $100,000 fee, H-1B fee, does not apply to petitions or visas that were approved before September 21st, 2025. That's getting further and further in the past, less relevant, but does not apply to petitions approved before 9/21/2025. It does not apply to current H-1B visa holders. And it does not apply to a foreign national following the petition approval from traveling in and out of the United States. And we'll talk in just a minute about what that means. It also does not apply to petitions that request an amendment, a change of status, or extension if the beneficiary is in the United States and if that change of status, extension, or amendment is approved. So for example, let's say that you have someone, and Neela, this goes to your question, somebody in OPT in the United States or STEM OPT, okay? They're working for your company on OPT, STEM OPT in the United States. And you register them in the lottery, they're selected, awesome, and then you file the H-1B petition. We request a change of status. That's tremendously important, that when we file, we request a change of status from F1, the student visa, to H-1B. In that case, the $100,000 fee would not apply, assuming it's approved, assuming the change of status request is approved. So they would then begin working in H-1B status as of October 1st, or whenever the H-1B petition is approved, whichever is later. You would update the I-9, with saying that they're working in H-1B status. Then let's say that in December, after they've been working in H-1B status, just an example, they say, all right, I want to go home and see mom and dad or whoever, go to a wedding, whatever it is. They want to leave the United States and come back in. They can get the H-1B visa stamped overseas and re-enter. Let me give you a caveat in a minute, but they can re-enter and the $100,000 fee should not apply in that situation. The caveat is there are a number of travel bans, partial and full travel bans, and I anticipate those will change over time. Maybe not, but I anticipate those will change. So I tell people all the time, clients all the time, please, please, please tell us if you travel, if you plan to travel, tell us ahead of time, not like on your way to the airport, okay? And tell your employees this too, to please let us know. We would rather get an email saying, hey, is it okay to travel? And us take the 5 minutes to respond to that and advise on that than somebody travel and then not be able to get back in or be subject to the $100,000 fee. So please, that's a side note, tell us if you or your employees travel. But if you have a petition, Neela and anyone else where the person is on F1 F1 OPT or STEM OPT or something else, you file a change of status, the $100,000 fee does not apply, assuming the change of status request is approved. I say that. I say that assuming the H-1B, the change of status is approved because it's possible for an H-1B petition where you request a change of status to be approved. The petition itself can be approved, but the change of status itself is not approved. That means that maybe USCIS found something in their past, a status violation in their past, and usually they're going to issue a request for evidence. So we're going to have a heads up on this, but they're found something in their past that means that USCIS determines that they have not maintained status. They can approve the H-1B petition, but approve it only for consular processing. In that case, the $100,000 fee absolutely would apply. So we want to avoid that whenever we can. So that's why I said a few minutes ago, the status documentation, the documentation of status, that's something that is critically important. We will, for anybody who we're registering, we cannot, it's not practical really to go through every piece of documentation of, status documentation for everyone that we're registering. Instead of doing that, we're sending a questionnaire that we need H-1B beneficiaries to truthfully answer to identify potential status issues so that we can then advise the employer and employee accordingly on the potential risk of a change of status not being approved. So just know that that's coming if you're registering with us. So if you have a petition approved, change of status, extension, amendment, and when I say extension, that includes H-1B transfers. Like I said, you have that approved, the change of status or extension, whatever it is approved, and then you apply for a visa later, then the $100,000 fee does not apply. In addition, the $100,000 fee does not apply to H-4 dependents or other visa classifications like E3, J1, TN. The fee does not apply to them. It does apply. The $100,000 fee does apply to situations where the H-1B beneficiary is overseas. So let's say that you have identified this really great candidate who is living in Colombia. You register them in the H-1B lottery, they're selected, you file the H-1B petition. They're living overseas, so you're going to have to pay the $100,000 fee for them to be able to enter the United States. Also, like I said, if you file a change of status or extension and that portion of the filing is denied, and you have to use consular processing, then the $100,000 fee would apply. All right, so it's 12:53 and I want to end at 1 so everyone can get to lunch or whatever exciting event you have coming up next. So I'm going to open the floor to questions. If you have questions, feel free. We have a couple here that we need to touch on. And then if you have questions, feel free to put them here in the chat here, or can you all unmute yourself? If you can, feel free to unmute yourself and ask questions. So I'm going to start here with, before I do that, we're being fluid here with the slides. Before I do that, I want to, in case you have to go, I want to outline next steps to proceed. If you are a current client of Sumner Immigration, current corporate client, you are an organization, employer, we will be in touch with you within the next week or so about initiating CAP cases if we have not already talked about it. So don't worry, we've got you covered. We will be in touch. If we have not worked together before, if you are an individual or if you are a new corporation and you're looking for support, we would be happy to help you. We have the bandwidth to take on new clients, and we would be happy to do that. The process, what that would look like is send us an email at info@sumnerimmigration.com, and we will send you the engagement letter that outlines the fees. We would gather the payment, and then we would start gathering the required documentation. Then once the registration window opens, we would submit the registration. And like I said, there's lots of coordination and communication. Not necessarily, like I said, we try to streamline it as much as possible, but transparency and clear communication is really important to us. So lots of communication about what's happening. In addition, you can scan this QR code if you would like and connect with us further. So we have information we have lots of videos on YouTube. I go live every week on Tuesdays at noon Eastern, and that live is on my personal LinkedIn page, which is linked here, our YouTube page, and our Facebook page, and those stay, even after the live ends, it stays, so you can take a look at those. This link will also take you to our Instagram, my personal LinkedIn page, where I post static posts frequently, several times a week, a link to sign up for our email newsletter, which comes out once a month on the first Wednesday of every month. So I hope that you will connect with us there. Email us if you have questions. And we also will have, I think there's a link here in this QR code. We have a page on our website that is an H-1B hub. So it has all kinds of information. It will have a link to the engagement letter, a link to a video overview of the process, an infographic about the process, FAQs. It's one centralized place that you can go for H-1B cap and registration information. So let's take a look at the questions here. Hirsch says, for cap exempt to non-cap exempt transfers, would the $100,000 fee apply? If you are filing a change of status in the United States, or it's not really a change of status, but if you're filing let's say that you file in the H-1B, you register in the H-1B lottery, you're selected, you file an H-1B petition asking basically for a extension of your status, your H-1B status, but you're changing from cap exempt to cap subject, then no. If the extension is approved, then no, the $100,000 fee would not apply. If for some reason that was not approved, then yes. If they approved it only for consular processing, then yes, the fee would apply. I'm on STEM OPT and haven't gone through the H-1B lottery previously, and this is the first time I'm going to H-1B lottery. So in this case, will the $100,000 fee applicable in this case? No. If you're in the United States right now on STEM OPT, and your employer requests, or the lawyer who's preparing the case, we request a change of status from F1 to H-1B. And if that change of status is approved, the $100,000 fee does not apply. The next question is actually what I was going to say next. Good question, Neela. What could be a cause of denial for the change of status or extension? Most likely a maintenance issue, a maintenance of status issue. So it could be that there's some previous immigration violation in your past. So for example, we had a situation, this was years ago, where an employee, we filed an H-1B cap for this person. We looked at their documents. We looked at all of their I-20s. We looked at their pay stubs, their recent pay stubs to show they're maintaining status, their history of I-20s, everything. Turns out that this individual had worked for an employer in OPT years ago where they didn't have pay stubs. Okay, and they just had a letter, and then upon further inquiry, it turns out that they actually weren't working for that employer. They were just being trained and not working, so they submitted the letter, unfortunately, and to be able to get the OPT and to make it look like they didn't have the unemployment, which would be a problem, and it was a problem. It came back to bite this person, and this person's change of status was denied because USCIS found that they had not maintained status, continuously since they had entered the United States. It was approved for consular processing, and it was before the $100,000 fee, but the person had to go for consular processing and then some additional steps there. So that's the type of thing. If USCIS finds that you have not maintained status, if you violated your status previously, CPT is, I think, a yellow flag. It is, not I think, it is a yellow flag for immigration. CPT stands for curricular practical training, and it's designed for when a person, if F1 student is taking a course or series of courses that requires hands-on experience, like an externship or a co-op or something like that, It can be properly used, but it also is not properly used sometimes. There are certain universities that are known for really making having a liberal interpretation too loose, I think, of the regulations, and they're not properly using CPT. And USCIS knows that and will issue really extensive requests for evidence and can potentially deny the change of status portion, but still approve the petition, but deny the change of status portion. And then the person would have to go for consular processing, and then the $100,000 fee would apply. You mentioned at the beginning, the cap and lottery do not apply to organizations such as universities as well as renewals. Am I correct? And if this does not apply to universities, can the application be filled out at any point in the year? If the if renewal of the H-1B visa happens 1 year. Okay, so correct. Most universities are cap exempt if they're accredited and not for profit. Most universities are cap exempt, and you don't have to go through this H-1B lottery even when you file an extension. So universities, and then we also have plans that are nonprofits that qualify as cap exempt, and you don't have to go through this lottery process for extensions or for the first filing. Haya asks, does the lottery cap and weighted selection, I think this is the same question, apply not for profit employers? There's a distinction between profit and not for profit. Yes, there still is. That is pretty much the same question, which is awesome. And you all keep putting questions here. It's 101, so if you have to leave, I totally understand. But if you have questions, keep putting them here, and I'm happy to keep answering them for a few more minutes. Yes, there is a distinction. So as I said before, certain organizations are cap exempt. That means they are not subject to this numerical limitation, and they don't have to go through this H-1B lottery. So cap exempt organizations include, but is not limited to, universities and institutions of higher education, and certain nonprofit organizations that have affiliations with a university. Typically, it's a memorandum of understanding. Anyway, certain nonprofits are cap exempt. So if a person is working at a cap exempt employer, unless that affiliation with the university changes, you're still cap exempt. And even if you extend your H-1B status in the future, you still don't have to go through this lottery process. If you were to change, for example, to a cap subject employer. So let's say you're working right now for a cap exempt employer and you want to change employers and go work for a different employer who is not a university or is not a nonprofit with this affiliation, then you would be subject to the H-1B lottery process. In terms of the weighted selection, that weighted selection only applies to the H-1B cap process, the H-1B lottery selection process. So it would not apply to nonprofit or to cap exempt rather organizations. So if you're working at a cap exempt organization, you don't have to worry about this, the weighted selection. Any other questions? Well, if you have other questions, like I said, feel free to email. As I said, in terms of next steps, if you are an existing employer, let me just a minute, let me put the hub. I believe, so I'm gonna do this. Just a minute, I'm gonna put the hub information right here. If you're an existing employer, then we will be in touch with you about next steps if we haven't been already. If you are not yet a client, like I said, we would love to help you, and feel free to send us an email to sumnerimmigration.com. Or sorry, and I'm trying to do too many things at once. Send us an email to info@sumnerimmigration, or you can connect with us, by phone, whatever way you're comfortable. And at least let me find the hub, just a minute. Darn it, it wants me to log into my website, like I'm gonna edit it. Here we go. Yeah, thank you, Cindy. Cindy beat me to it. So it's right there. And that, if it's not already, I think it is already updated with the information. So it will have, that hub will have, let me actually, stop sharing for a hot minute. And I'm gonna go to that page for anyone who wants to stay on and see what's actually available on that page. Okay, so the hub is here, H-1B cap. So we have information here about our fees. If you're an existing corporate client, look at the engagement letter. That will be where your fee information is. If you want to initiate a case, you can click here, and that will take you to the step-by-step way to initiate a case. Webinar registration is here for upcoming webinars that we will have. Video resources are available here. An overview of the H-1B cap timeline is here. More essential information is here. What is the H-1B cap, when to register, that kind of thing, and then how to prepare. And like I said, we're happy to answer any questions that you might have. Thank you all for joining us live. I think it makes a big difference to join live. I know not everybody's able to. I sign up for webinars all the time. I'm not able to come live. But I appreciate you joining live because I think that gives you the chance to interact and ask questions, which I think is valuable. So thank you so much for coming. I hope to hear from you soon. Take care.